Okay, well, thank you, everybody. We'll call the meeting to order. Comes our other committee members. Mr. Secretary, if you'll call the roll.
Wiggins, Blackman, DeVar, England, Fillingame,
Here.
Hill, Jackson 32, McCawn, McDaniel, Simmons 12, Sparks, Suber, Thomas, Thompson, Turner Ford. Mr. Chairman, quorum's present.
Okay, and I did see Senator McDaniel here, so he was here. Okay, thank y'all. Just a little housekeeping. First of all, thank y'all for being here. We will do the whole honor the social distancing so that everybody's safe. Just a little housekeeping. We're meeting under the standing meetings, and we usually have a standing meeting on Wednesdays at this time. We will not meet tomorrow, so it'll be just this week. And the plan is that we have received double referred bills from the House. I'm not really sure how many, but we have received them where we're the second committee. So the plan would be that if the first committee passes those out, that we would meet to take up those double referred bills, depending on what they are and all that. Also, we have a couple suffrage bills, so the plan would be to, depending on the deadlines, to take that up. I'm kind of going to do what Chairman Bryan did, and maybe closer to the end of the session on that. But if you have any suffrage bills, get those in. According to Karen, there is no specific deadline on that. So that's how we'll be going forward. So right now, plan on to do the double refer bills will be next Tuesday at this time on that. So with that, and I'm going to take a little liberty here. I do think we'll meet again, but I just wanted to say, I guess I didn't realize, but Karen will be retiring July 1st. And I just want to say thank you, Karen, for everything that you've done for this committee, for me, and your years of experience. How long have you been?
This is my
29th regular session. So thank you, and you deserve a round of applause. So thanks, Karen, for all that you do. All right, we're going to go. I'm going to skip around the agenda just to move some things along. The first bill, I call up HB 1314. That is the companion bill. Oh, that's the companion bill to the bill that we passed on the tribal identification, Senator Branning's bill. And the only differences between our bill and the House bill is some technical changes. So Senator Branning is here to talk about it if you want to, but it is the same bill that we passed. So I'd be happy to entertain a motion. Motion's title sufficient, do pass. All in favor, say aye. Aye. All opposed, motion carries. Okay, let's see. Then let's go to House Bill 1135. There is a strike all on that, and Karen, I will ask you to help keep me focused. What the original bill, you remember, we passed off the Senate floor, which ultimately became Senator McMahon's bill. We had a lot of discussion about vehicles being used by officers, off-duty officers, and things like that. So the House Bill 1135 is effectively doing the same thing. However, the committee sub, the difference is that the strike all has the bill that we passed off the Senate floor. So for our freshman members, with the strike all going into that, that means that I guess both the House and the Senate bills, as we are up for negotiation in conference. So so that's what we did with the strike all on that. So entertain any questions. Thank you very much. That's what I asked. We also we did that plus the House had the bill where, so they sent us 3 bills. We've combined a couple here, and where, we had passed previously the, firearms upon retirement of officers can be kept, okay? The House bill allowed firearms of state agencies, so your investigators and all, that's what that did. So we've included in the strike all, the House bill that did that as well. Thank you. Right. Thank you. Right, and so if you recall, when we did our discussion, it was all about insurance and who was gonna cover what and all of that. The original bill had the original House bill had the municipalities and all covering the insurance no matter what. If you recall our discussion, we had them being named as an insured, okay? So that's why we put the strike all language in here, and that could end up, being for discussion on that. So that's what she's referring to, section 3. Yeah, the House had, for volunteers. So, right, if they're volunteering, it's allowing municipalities and local jurisdictions to allow their officers, if they're volunteering, and as we did, to use their vehicles, which was Senator McMahon's bill, and then state agency, which is starting at line 149, the firearm. So this all falls under the category of these local jurisdictions. So I'm happy to entertain any questions. Thank you, Karen. That's why. Yes, Senator Turner Ford.
I'm not clear on your explanation.
I'm not surprised, so I'm sorry about that.
What all does this entail in section 3?
On the proposed committee substitute? Okay. So first, we passed this session the bill that allows for local sheriff's vehicles or law enforcement vehicles to be used in private situations, and we put in the language about insurance and things like that, okay? The strike all includes our bill that we did, plus the strike all. The House sent us one bill that said that upon retirement, a state agency officer can keep their firearm. The current law is that if it's in a police officer, a sheriff's deputy, we passed that law a number of years ago that they could keep that. So this is simply adding the state agency portion of that. Then the House sent us also a bill that if they're volunteering, that if they're volunteering at functions, they can use the vehicle and their firearm and all that. So this committee sub is including all 3 of those. Hopefully that was better. Yes. Senator Blackman. That's the new.
Okay, so we are, if someone is employed by the county or the municipality, and they, sue for negligence based on something, the county or municipality will be responsible for that.
Yes, that's how the House sent us the bill. Senator Sparks.
Does the passage use volunteer service? Is there a difference between volunteer or off-duty? I didn't know if that was a distinction just because it said volunteer.
I do not know that it was defined. Karen? no.
I didn't know if volunteer might be, I'm volunteering to work at a school or a ball game versus I'm working for a private security company. That might be a distinction. Thank you. Right, and I may be confused. I thought the question might have been that we were making liability stick to the county if somebody was hired through private security, and I don't think that's what it was meant. It was meant under the
Oh,
volunteer
in
portion.
the original, well, yeah, there's different sections, but in the original House bill, that's what they did. That's why we've done a strike all and put our bill into that. And, so, because honestly, there's a difference of opinion there, to be quite honest, to your point, Senator Sparks. So, yeah, and the language that you just referenced of the House bill, that's moved. That's why we put our strike all in there.
Thank you, Mr. Chairman.
Senator,
Mr. Chairman,
yep.
I'm having a little difficulty in hearing our our attorney. Can you help me out a little bit with a mic?
Having a hard time hearing you. No. Was there a question for her? Okay. Senator England, I think you had a question. Oh, okay, Senator Hill.
So on the proposed strike all, the only way the county would be liable or municipality would be liable is if it was on a volunteer basis, and if they were getting paid, the city or county would not be liable. Am I correct?
That's how I read it.
As I understand it, yes. And again, Section 3 is the House language from.
Okay, I don't have an issue with the volunteer, but if they're getting paid, and they're by some other entity, in my opinion, they shouldn't, the liability of the taxpayer should not, cover them if they're out getting paid by somebody else. So I just wanted to clarify that.
Okay. Yes, Senator Turnford.
Thank you, Mr. Chairman. I'm looking at line 126, and it says, acts and omissions of an officer in discharge of volunteer service shall be deemed to be the acts and omissions of the county or municipality employing the officer.
Yes.
Why do we need this provision in the law?
Well, that's what the House sent us. I don't have the author of the bill here. I think if in briefly speaking with the chairman, I mean, that's what they're saying. I think they had the same discussion that we did, and it was the decision made that that the municipality should take on that liability, whereas our discussion was, they become a named insured. So why they drafted that way, I can't answer that.
So what we're doing is creating a situation I guess there's a requirement that if the volunteer officer is going to be in uniform, this must be approved by the board.
Now, that's correct, yes. The city, they have to approve it, just like we talked about in ours. They have to approve it, they have to put it on their minutes, they have to accept it. They can't go do it, the officer, and then not have that put in place by the municipality or whatever.
And so whatever acts or omissions that occur regarding the officer in volunteer service, we are creating a situation where a liability attaches to
The
the
city,
county or the city.
that's right.
Thank you.
Okay, Senator Simmons.
Thank you, Mr. Chairman. As a follow-up to Senator Hill's concern, just like the language we added on lines 54 through 56 as it relates to automobiles in the Senate's original bill, would it be a friendly amendment to include some type of language when a retired officer is working for some private company who contracts with a municipality or county then even though if the board or the city approves it, that company should also be named insured regarding any general liability for any acts or omissions committed by that private company to a third party.
Are you referring to the proposed committee substitute, the line?
I probably need help with Karen on where to put it, but
Because if I understand what you're saying, if you look at the proposed committee substitute in that line, that's the strike all language from our bill that we passed that had that in it.
yes.
Okay,
And what I'm saying is, in lines 54 through 56 is our original bill.
yes,
It's now in the proposed strike-off.
correct.
But language that we are adding that was not considered by the Senate is language where a officer uses his or her uniform, is engaged in some kind of volunteer service, and based off what we just read at lines 126, the acts and omission of an officer will become the acts and omission of the actual county or municipality. I'm fine with that in the event they are volunteering, but in the event the officer is hired by a company that the county or municipality is using.
Well, if you have an amendment,
Okay.
certainly we'll entertain.
So my amendment, and I don't know where it should go, but my amendment would be to mirror the language that we have at lines 54 through 56. So when a retired officer or anybody who is using a uniform is contracted by the city or the county, any acts or omission regarding a third party, some kind of way that private company should be a named insured.
Okay, I'm having a hard time understanding the
Okay.
amendment, so,
All right, so let me start over again.
huh,
Officers that are working with counties and cities, and it's approved by the board, and it's a volunteer service, that's fine. But if it's a company that they are working for, and it's not a volunteer service, then I would like to have language in our strike-all that mirror the same language that we had in the Senate original bill when they're using a vehicle, which is that private company should be a named insured. The county or the city should be a named insured for that private.
if I understand your amendment, the language that we used in our bill that we passed, you're wanting to apply that to the volunteer service?
No.
No? Okay, then I didn't understand.
If it's a volunteer service, we fine.
No, go ahead, that's fine.
Karen,
You
could
understand the amendment?
Do you understand the amendment, Karen?
Can I speak to that?
Yes, Senator Hill.
Just briefly speak to Senator Simmons's amendment. I think if you look at lines 47, 48, 49, 50, and 51, I think that language takes care of what he's talking about, where it says, if they're actually employed, an employer employing the officer for private security services shall hold harmless the jurisdiction by which the officer is employed and fully indemnify the jurisdiction for any expense, loss, including attorney's fees, which results from any action taken against the jurisdiction arising out of the acts or omissions of the officer in discharge of private security services while wearing an official uniform, using an official weapon or vehicle, and name the jurisdiction as a named insured on its general liability and automobile liability policies. I thought that took care of it, but maybe I'm wrong. I think that's what Senator Simmons is attempting to do. It's hold the jurisdiction harmless if the officer is getting paid by a private security firm.
That's correct.
Okay, so you'll withdraw your amendment?
I was wrong.
Okay, thank you.
Thank you.
All right, do I have a motion, on the, strike all?
Title sufficient, do pass, strike all.
Title sufficient, do pass, strike all. All in favor, say aye.
Aye.
All opposed?
No.
The ayes have it. All right, so next going to, going to call up House Bill number 544. So you have before you the House bill and then the proposed committee strike all. The House bill simply, dealing with the DUI, states when the 120-day period begins to run. My understanding is there is discrepancy out there as to when the 120-day period begins to run, in the sense that in the courtroom, the judge makes the order, they think it starts then, and then there's a time delay, to say the least, from coming from DPS, and then the effect is there ends up being, they could actually be without their license for more than 120 days. So that's what the House bill does. Okay, so now the strike all doesn't change the House bill, but simply adds in a bill that actually Senator Parker had that fixes the equal protection issue about prior convictions on DUI coming from other states. The argument had been that if you had an out-of-state conviction, actually it was I guess against people who were convicted in state. So does that, if you want to look at that link, does that make it clear?
Starts on line 343.
Thank you.
343, subsection 7, out-of-state priors.
And Karen, can you explain the equal protection issue that's going on?
The equal protection issue has been if you, so 3 or 4 years ago, y'all went to a system where you had a fourth or subsequent lifetime greater penalty. So they put that in the, and when we got to the part about out-of-state, got to conform that where fourth or subsequent, including an out-of-state conviction, count as a fourth. So, you know, there's a 5-year limit. If you can offenses down to 3 offenses in 5 years, it rolls off your record. But now, if you're state, fourth and subsequent, it's a lifetime prohibition, or not a prohibition, but there's just that greater penalty for fourth and subsequent forever. It doesn't. Once you get to the fourth, it doesn't roll off your record in 5 years.
So
the state was set up that way, but we didn't conform out-of-state priors. So now, if one of your 4 convictions is out of state, you might escape, which may invalidate the whole fourth and subsequent.
if I may do it another way, that if your convictions are in state, you're receiving a harsher penalty than if one of your 4 convictions were from out of state, and therein is your equal protection issue.
Right, and it imperils the concept of fourth and subsequent across the board. And I think some judges are either ruling that way or they're talking about it.
And that's for the benefit of our newer members. This DUI statute has been amended the last few sessions. Senator Parker has been involved in that. That's why he had this bill to do that, to fix this equal protection issue. So we've included this in the strike all. Does that make,
Yes.
I see Senator Hill nodding over there. I think she knows. Does that sound right, Karen? Good. Okay. Yes, and we also, I'm sorry, in the strike all, we had also passed that Senator Simmons' CDL bill, where if you were in a private vehicle, you weren't being held, you had to be in a, I'm sorry, you were in a private vehicle, you weren't you were allowed to be non-adjudicated and all that, and that's in the strike all to do that. Yes, Senator Simmons.
One question, Mr. Chairman, about the out-of-state prior conviction, language. So, the effect of the language is so that you can start counting, if I'm understanding, you can start counting the convictions even if one of the convictions happened out of state. Is that correct?
Correct, because as I understand it now, that if you received one of your 4 previous convictions or 3 previous convictions was in Alabama, then that would not get counted towards a 4th DUI. Whereas if you were a Mississippi and you had it in Mississippi, then it would be counted.
And so my only concern about that is, did we or have we considered the reverse, in that if a person receives a conviction in a state that does not allow non-adjudication on the first, what effect would that have on the actual defendant or the petitioner? In that Mississippi allows non-adjudication on the first, but they actually got a conviction on the first in a state that does not allow them that benefit.
I have not considered that.
Okay.
All right.
The language that's being deleted takes out the 5-year window for look back, perhaps for the 4th and subsequent. That's what's in some of these stars. 5 years, like insect convictions used to be.
Habitual drunk driver.
Yet, to go 5 years, then have some roll off.
All right, do I have a motion?
Title sufficient, do pass, strike off, committee strike off.
Motion is title sufficient, do pass, strike off. All in favor, say aye.
Aye.
All opposed? Okay. Let's see. Okay, want to go to call up House Bill 1024. The 1024 deals with habitual offenders. It is a look back, and on both the big and the little habitual offender statutes, it puts, I think it's a 10-year look back. There is a reverse repealer in this, and that's really what it is. This is, I will state, Chairman Bain had filed this. This is part of the criminal justice issues that we've been addressing this committee, as well as corrections. This is one of those that we're trying to address with that. Happy to take any questions. Oh, and let me say this, on the committee strike-all, I'm sorry. What the House bill did was they included, and Karen, you can fill in, a lot of the probation and parole statutes. There are, in various places, there are quite a few bills that have those provisions within it, and operating under the guidance that simpler is better. The committee strike-all removed those provisions, has the reverse repealer in it, and just deals with the look-back provisions. That, Senator Hill?
Just basically because these criminal justice statutes are all over the place and refer back and forth to different sections of the code, just want to ask that we have some type of summary before, we vote on this final thing, because quite honestly, I can't keep up with it. And I want to know what I'm voting on or not voting on. And nobody can flip back and forth and look at all these statutes at one time to see what's changing and what's not changing. And I'm good with some of this criminal justice reform, because I don't think that somebody that's, done some of these minimal things ought to be locked up for the rest of their life. But just want to make sure that things are not falling through the cracks that, we might otherwise miss on some of these more serious crimes. And that's just my
I think that's a totally fair request, and I think your observation is right. And, you know, we sent a bill to the House. I'm not sure where that's gonna, my assumption is that'll be moving through. There was a reverse repealer in there. So, to your point, I think that's a totally fair request.
Because when we come back after conference, you know, it's something that we actually need a little time to digest, or at least I do, because these are some of the more difficult statutes for me to comprehend what we're doing and what we're changing from old law to current law. So that would just be my request on it.
And in section 3, you'll notice there's the reverse repealer in the strike all. So, have a motion? Motion is title sufficient, do pass, strike all. All in favor say aye. All opposed? Okay, ayes have it. Let's see. Okay, call up House Bill 658. A little bit of discussion here. I put this on the agenda to, for the committee to discuss. You have before you a couple things. You have the original bill, which the original bill is amending the expungement statute to, as it pertains to multiple drug convictions. I will tell you, in my review of it, I think there were some questions that was confusing at a minimum. Okay, then what you have before you is what I call for the committee sub number 1. But then as of this morning, what you have before you in this document is an amended, what I would call the committee substitute number 2. The long and short of this is I put it on here because in keeping with our legislative practice, certainly this session before, to get people employed so that they will not have prior convictions held against them if they're trying to be employed and they've met all the requirements that they will, that we can expunge it. And this expungement statute has been amended over the last couple years. And however, both from personal experience and from talking to constituents as well as other practitioners, there are some holes where people are still falling behind. For example, I'll just give you an example that there's a guy who had a conviction from 20 years ago that was like, I think it was grand larceny or something, and because he couldn't get it expunged, okay? And he was not able to get the work or whatever he was doing. So on the number 2, I think, is a better option that we're looking at, and number 2 does have a reverse repealer in it. If you look at, it's been divided, which is simply put like misdemeanors and felonies. If you look at where it says misdemeanors, any court, you can expunge it, including if the result of a plea agreement. And what I have seen personally, and I've had other people talk to me, is that, and Karen, you can maybe offer this, but back in certainly the early 80s and all of that, things got ratcheted up, and you've had people plead down from a felony down to a misdemeanor, which wouldn't happen now, but they can't get it expunged because it's a felony at the time they were indicted. Okay, so there's that. Then under the felonies title there, if you will, that the strikeout language is the language from the House bill, and you cannot expunge the listing there. That's current law, crime of violence, arson, trafficking. That is the current law that's already there. And what this allows, the felony currently was limited to, I think it was a first-time offender or something like that. Okay, so it's replacing the 5 with 7 years, and then and applying, if you look at towards the end, shall apply to applicable convictions prior to the enactment of this law, with the idea that that will capture these folks who are not, who are being prohibited from expungement. You cannot, current law is you cannot expunge, if you're a public official, you cannot have your conviction expunged if it's a public act. So what we're trying to do is address the expungement statute in this, with this bill. The House bill got into the drugs. By the way, you can't, under the proposals that you have before you, you can't expunge trafficking, that you can't expunge a violent offense, you can't do that. So it's trying to allow folks who are in this position to be able to go back and petition the court for an expungement. So that's my explanation, and I'm happy to answer questions. Well, Senator Hill.
So is this going to allow public officials expungement of public acts, or is it still excluded?
No, if you look at, and this is current law, if you look at the last, it's section 5, no public official is eligible for expunction for any conviction related to his official duties. That's current law.
So what's actually changing from current law in this strike-all? They would have to, it would have to be a 7-year period after everything's completed and they've served their sentence. They would have to wait that 7 years?
Current law, if you look, current law is 5 years, you're only limited to 1 in 5 years, okay? So this is saying 7 years, and as long as you meet that and it goes 7 years, then you can petition the court for expungement, and the judge still has to sign off.
For multiple expungements?
Yes, and I should say this, that the House bill and the original bill sent over, that was their bill, which is multiple convictions, and their bill,
As a common nucleus, or just any multiple conviction?
drugs, but it related all the way up. If you look, it's before you in your packet.
Okay.
Yeah. That answer your question?
Somewhat, thank you.
Senator Simmons.
So, Mr. Chairman,
Yes.
we're looking at this handout, right?
I am, in my analysis or my explanation, I'm referring to that, yes.
Okay.
Have a reverse
And so, I'm looking at to lines 22 through 24. That was the language that passed the House.
Okay, that's the language that passed the House, that's correct.
And
And then the one, so the language that in the case, controlled substance, multiple convictions, 41, 29, all, that's the House language.
and so, I guess a comment and I guess a question. As I understand it, under our current law, because I do expungement.
Expunge prescription.
I'm sorry?
I say I do expungements. And so what's happening is, in our current law, you only could have one expungement, and it also has to be a nucleus effect. So a person will make a petition, and the only way a judge will consider, say, more than one if it happened around the same time. So a person may have very well committed a grand larceny and was charged with grand larceny as well as possession of some drug that he had on him at the time they searched him.
And you're talking about under current law?
Under current law, yes,
that's
sir.
correct.
But what's happening, because the language that the House passed is targeting those situations where you have people who have been rehabilitated in drug court, but they had an addiction for a long period of time. So what'll happen is, if I'm a drug addict and I actually was addicted to drugs for a period of 3 years or 4 years, what would happen would be, I would get a grand larceny charge in year 1, and based off the lawyer I had, or based upon my inability to understand the system, I actually pled or whatever, and my drug problem never got addressed. So in year 4, I get caught with some drugs, and now, based upon my lawyer or whatever, or the DA, drug court is offered to me. And now,
That's correct.
and now I go to drug court. And now I go through drug court for 2 to 3 years. I successfully complete drug court, but the problem with me trying to re-enter society and trying to actually start my life over is I have 2 separate felonies that happen 3 years apart. Both are nonviolent. Both are not excluded under our current law under 9732 as crimes of violence. But according to our current law, I can only petition the court for one of those two felonies. And a judge will grant the expungement on one of them, but I still can't get a job because one is still on my record.
That's correct, and to add, first of all, that is correct, and to add, when you go through drug court, the expungement is related to the charge you went into drug court for, okay, not any previous ones. Like you said, the drugs, grand larceny, property crimes are committed as a result of an addiction to the drugs. Is that what you're saying?
Yes, sir.
So that's that. And then on the one, based on my research, if you actually go back and look a couple years ago, that limitation of one was not in the law.
Yes.
It was actually I think it was a 10-year, what happened was it was a 10-year look back, and there was no limitation on one, and then whatever happened, this one, and it became a 5-year look back. I don't know what happened. So I think if you look at the history of this statute, that's what's been going on, and we're trying to get it to a place to do what you're talking about, I think, which is you go through drug court and you can expunge the grand larceny that you committed while you were on drugs, and that way you can get your job and you can do that as long as it's a nonviolent offense. It's not under all of that stuff. Is that where you were?
Yep, and I just want us to continue to look at that because the language that passed the House, it was targeting those situations where they hadn't committed violent offenses.
Right, and I think that with the language, the proposed strike all that we've been looking at, I think does the same thing, okay? Because the House bill, I will just tell you, is drugs. The way I read it is convictions under 4129-139, okay? It wouldn't capture the grand larceny. I think the proposed committee sub would do that. So I think we're trying to get to the same place. Senator Thomas.
Thank you, Mr. Chairman. Just from 10,000 foot, have the district attorneys weighed in on this at all? Do they have any opinion one way or the other?
So it came to us from the House. I didn't hear anything. I've not heard anything on this. Under the current law and the law in the proposed committee sub, the district attorneys have to be notified and have to weigh in at court and sign off on it. So procedurally, what already happens on expungement is a motion gets filed, you cite the law about, hey, I want to expunge it, you notice the district attorney, then the district attorney appears, says, well, I don't want it, or whatever, and then the judge does that. So their right to weigh in on all of this under current law and the proposed committee sub is preserved. Is that it? Yeah. Yeah. Okay. Do I have Senator DeBar.
Thank you, Mr. Chairman. On line 25, we're going, it's my understanding with expungement, and correct me if I'm wrong, the current law says you have to wait 5 years from the date you're off paper, basically, to apply for.
And you're only limited to one.
Correct.
To one expungement.
But you wait 5 years.
That's correct.
And then we're changing it to 7 years now?
Correct.
Why are we changing it to, what's the rationale
Well,
for that?
because the way this is drafted is you're not limited to just one.
So you can have multiple expungements then?
Yes, which is the House bill that sent us, was
Okay.
you can have multiple expungements. For the drugs.
Okay, thank you.
And I know it can get confusing, and me personally, I value your input. That's why I put it on here. Just like the DUI, we've tried to address this statute over the years. It used to be you couldn't expunge basically anything. Then it went to, if there was 10 years, you could expunge a whole bunch. Then it went to 5 years, but you were limited to one. So we're kind of all over the place, to be quite honest, and to be upfront. And we're trying to, I think the House with their bill, I think with the proposed committee sub where we are, which by the way has a reverse repealer, we're trying to get somewhere where it can satisfy these problems that we're seeing. Real quick, because we've got.
All right, so I just
10
want,
minutes.
as a follow-up to Senator Barr's question, I just want the members of the committee, Mr. Chairman, to understand that the language in the current law, which we're not changing, is after successful completion of all terms and conditions. So what's happening in the real world is a person will get a conviction in 2000, and they would not go to jail, they would not go, they would not go to prison, and they won't get in any trouble, but they won't be able to, or they hadn't been able to pay the fines and assessments. So what happened is, for 3 or 4 years, they hadn't gotten in any trouble. If the DA gave them 3 years on a possession charge or whatever, they hadn't gotten in any trouble. They're trying to get a job. They can't get a job because they got a conviction. And so they've met the requirement regarding the probationary period, but they just have not been able to pay fines and assessments. So say it takes them another 2 years to pay the fines and assessment, and now they're at 2005, and they paid the last assessment to the court. According to the current law, they would not be able to petition the court for expungement until 2010, because that's 5 years after the successful completion of all terms, even though the conviction itself happened in 2000.
Well, current law, looking at lines 25, on current law is after the successful completion of all terms and conditions of the sentence for the conviction upon a hearing as determined in the discretion of the court. Okay, that's current law, and that may be the case. I will tell you, which you probably know, and these lawyers who practice, if you complete everything, and probation and parole has the discretion to discharge you from probation and parole. And my experience has been that, yeah, while they want the money, they also want to reduce their caseload. So if you've done everything and you have, whatever, $100 left, they'll discharge you under current procedures. And our former colleague, who will now, I assume, be DPS commissioner, you can take it up with him.
Well, we're going up to 7, though. We're going up from 5 to 7, though.
I understand, but we're also removing. Right now, they're limited to 1, and now with the change, you can go beyond. So, all right, we got the last question because we got to go in at 10.
Thank you, Mr. Chairman. It's a quick question. Looking at line 29, to expunge a felony classified as, and we're removing these felonies that are itemized here.
No.
Is that so? I need to understand what's going on.
Okay, no, those are current law, okay, and I don't know, in the drafting or whatever, the lines got put there, but understand that current law is you cannot expunge a crime of violence as defined there, arson, trafficking, so all that listing, and this proposed committee sub is not changing that.
So those lines don't mean anything. Those are errors.
Yeah, I think we were running out of time. That answer your question?
Line under the Arabic numeral?
He was looking at line.
Looking at the lines under the Arabic numeral?
Right. Is that language being deleted?
It used to be a Romanette 1, and now it's going to be an Arabic in a parentheses, and only with his change of this draft, it'll actually go back to Romanette 1, 2, 3.
So it's just the numbers that are changing.
Yes, ma'am.
That's correct.
And because that was not really my question. My question was, it appeared as though that was being deleted. My question was, where was this as the colon? Where does it pick back up? So I guess I've gotten the answer in a roundabout way. Thank you.
Okay. So with that, do I have a motion? Motion is title sufficient, do pass, committee sub as discussed. Okay? That's it. Do I have a rise and report? Rise and report. Thank you all very much. Appreciate it. Oh, I'm sorry. All in favor, say aye. All opposed? Thank you. Now rise and report.